Dear viewers, due to continuous rise in the number of COVID cases and the fears of a new wave, we are forced to switch the program to voice-over mode for a few days. As soon as the situation gets back to normal, we'll be back with the original format of the program. Thank you for your cooperation. Hello and welcome to another episode of the new series. I am Pooja Dwivedi, and in this segment today we are going to discuss about, is there a right to promotion? This topic is very important from this perspective of prelims and also from the perspective of GS Mains paper second. Let's move on with our first topic of the segment, which says that the Supreme Court on Friday has held that the state is obligated to collect quantifiable data on inadequacy of representation before providing for reservation and promotion for SC, ST employees, and they said that they can't lay down any new yardstick. So with respect to this, we have to talk about the verdict. First, a 3-judge bench headed by Justice Nageswara Rao and comprising Justice Sanjeev Khanna and B.R. Gavai, they said that states are obligated to collect data on inadequacy of representation of SCs and STs. That means without any proper data, policy making won't be done. The court also clarified that cadre should be considered as the unit for collection of quantifiable data and not the entire service tenure. Collection of quantifiable data is mandatory apart from assessment of inadequacy of representation after periodic review is done. The court also said that Nagraj judgment would have prospective effect. Now, for background, in 2006, we are going to discuss about M. Nagraj and the other important cases in much more detail. This is just a gist. In 2006, a Constitution bench ruling in the M. Nagraj case made it incumbent upon the states to collect quantifiable data showing inadequacy of representation of a section of people in public employment. It was endorsed by another Constitution bench by its 2018 ruling in the Jarnail Singh case. It also mandated the exclusion of the creamy layer before providing for reservation in promotion. After noting that the union government had not collected data on the inadequacy of representation of SCs and STs, the Delhi High Court in 2017, it quashed the memorandum which was provided by the Department of Personnel and Training of 1997, guiding reservation and promotion to employees belonging to SCs and STs. In this memorandum it was. The Union government last year cautioned the Supreme Court, saying that any modification in the current policy on reservation and promotion of people belonging to scheduled caste and tribes would only throw the entire country into chaos. From the very beginning of service rules, a roster system has been followed to provide for reservation of SCs and STs and other backward classes, limited to 50% of the total posts. Since the proportion of the population of OBCs to the total population of the country was 52%, which was according to the Mandal Commission report of 1980, reservation of posts in proportion to the totality of their population would defeat the limit of 50% as it was laid down in the 1992 case of Indra Sawhney. This judgment was also there. So reservation roster basically is an application to determine the reservation of posts in a cadre for different categories with reference to the applicable percentage of representation. And this has been followed without anything else being taken into consideration. For that very reason, no other methodology is being endorsed by the centre. So, with respect to constitutional provisions and important judgments, first we have to talk about Indra Sawhney versus Union of India, where a 9-judge bench held that Article 16, Clause 4 does not grant reservation and promotion because it pertains only to reservation and appointments. So, in 1995, the government nullified the effect of Indra Sawhney by introducing Article 16, Clause 4A through the 77th Amendment Act of the Constitution. Article 16, Clause 4A allowed the states to provide reservation to a SC/ST in matters of promotion to the people belonging from the scheduled castes and scheduled tribes. In 2000, through the 81st Amendment, the government introduced Article 16, Clause 4B, which allowed reservation and promotion to breach the 50% ceiling set on regular reservation. The amendment allowed the state to carry forward unfilled vacancies from previous year, which came to be known as the carry forward rule. In the 82nd Amendment, the state added a provision to Article 335. According to this article, the claims of SC/STs to reservation and posts have to be consistent with the overall administrative efficiency. So, as we see, efficiency has to be maintained. And in the 85th Amendment, Parliament amended the Article 16 Clause 4A and introduced the principle of consequential seniority to promoted SC and ST candidates. Consequential seniority allows reserved category candidates to retain seniority over general category peers. If a reserved category candidate is promoted before a general category candidate because of reservation and promotion, then for subsequent promotion, the reserved candidate retains seniority. So this is consequential seniority. In M. Nagaraj versus Union of India, Article 32 was invoked by the petitioner. The nature of that was writ and it was certiorari. Tell me in the comment segment what is certiorari. In order to quash the Constitution 85th Amendment Act of 2001, Article 16, Clause 4A of the Constitution, retrospectively from 17th of June 1995, providing reservation and promotion with consequential seniority as being unconstitutional and violative of the basic structure. Judgment laid down 3 important conditions that the state must follow before granting any sort of reservation and promotion. So first was that the state must allow backwardness of the class. Second, it must show that class is inadequately represented in the position or service for which reservation and promotion will be granted. And it must show that the reservations are in the interest of administrative efficiency. So, in 2017, there were many challenges to this case of Nagaraj, and the Supreme Court was asked by many states to reconsider the judgment. Now, in 2018, the similar viewpoint was endorsed in the Jarnail Singh versus Lakshmi Narayan Gupta. And one more important addition was the creamy layer thing. So, creamy layer doctrine basically. The Supreme Court upheld the 2018 Karnataka Reservation Act on the grounds that the state had furnished sufficient data to demonstrate that both these SCs and STs are inadequately represented and that policy would not adversely affect efficiency. So, the 2018 Act introduces consequential seniority for SCs and STs in state government service, and the court introduced a new inclusive definition of administrative efficiency under Article 335 of the Constitution. So there are many challenges that are yet to be overcome by the center basically and everybody who has a stake in it. First, that there is a lack of political will with respect to new methodology, as the center has already shown its stance by saying that right to promotion is not actually a fundamental right. And the Supreme Court has said that proper and important data should also be presented before we get into any sorts of reservation and promotion. So right now there is a lack of political vigor and will with respect to the new methodology for correcting it. If the current exercise of roster-based reservation system is held to be bad in law or in breach of the Constitution bench rulings, the court would have to necessarily accept the proportion of the population as the right indicator for measuring inadequacy. But this would result in an extraordinary situation. This is I'm quoting from the center actually. So there is a lot of issue with respect to providing reservation every now and then in appointment and promotion. The country is becoming too much reservation dependent. It is also ignoring meritocracy, who are meritorious, who have lots of administrative efficiency. For them, it can't be very underwhelming. So first, we need merit to be not ignored. Secondly, we need administrative efficiency to be upheld at the same pedestal. Also, providing reservation on a regular basis to those who have already been appointed through reservation and then again getting reservation for promotion, it actually perpetuates the caste system for a longer period of time. Another thing that we would like to add over here is there is a way forward with respect to policy support. It should be balanced or based on a balance between administrative efficiency, as the court has said, and also benefit to the downtrodden. There are certain instances when a person might be made to feel like he or she is not deserving enough of some kind of promotion, and some sort of discrimination is also there in the current structure. So in order to overcome this negativity, reservation and promotion can be a good tool. But meritocracy cannot be ignored. Populist policies, although they cater to the masses with respect to SCs, STs and OBCs as well, but they should be based on scientific evidence and not just because of election and vote grabbing. Consensus building should be there between different stakeholders, and it should be on a basis that not only those who have gotten reservation at every stage of their life to have all the the entire piece of the cake, the largest piece of the cake, but also those who do deserve it and they do not belong to the creamy layer of SCs and STs, they should also get the similar chances. So now let's move on to the question. Right to promotion is not a fundamental right. Discuss in 250 words. That's it for today. Tomorrow we shall meet again with another segment. Until then, stay updated and thank you so much for watching.